So, I'm going to make a statement, and I believe that AEP is in violation of their license today, and I'll tell you why. And the way I'm going to do that is I'm just going to read you some quotes from the law and from FERC, which is the law in Appalachian's case, and tell you what they think about this. Well, the FERC has ordered, and I'll read this because I don't want to mistake the actual quote. This is what the Commission has said. The Commission has regulatory authority only over the licensee and thus can administer and enforce the terms of the license only through the licensee and the licensee's property rights. That's exactly what we've talked about up to this point in time. If there is a question concerning specific property rights, it will have to be resolved between the property owner and Appalachian in a property law action in a court of appropriate jurisdiction. That means state court. Just what we talked about. The SMP applies only to those lands in the project boundary where Appalachian has property rights. The licensee has no authority to regulate construction on privately owned lands unless the property owner has given the company those rights. Guess how they get the rights? They get you to sign a permit. They induce you to sign a permit under threat of litigation. They'll take you to court and sue you, and it's going to bankrupt you. Or they tell you that the FERC gave them the authority to do this, neither of which is true. Well, what state courts say about their property rights? What state courts say about, Virginia state courts say about what the flowage easement means? Well, the Virginia Supreme Court, since 1987, has had 3 rulings that really interpret the meaning of what Appalachian's flowage easement really is. And I'm going to read what the court has said. When a landowner conveys a portion of his land, he impliedly conveys an easement for any use that is continuous, apparent, and reasonably necessary for the enjoyment of the property conveyed and in existence at the time of the conveyance. What that means is this. This was a lawsuit in 1987, Brown versus Haley. And in that lawsuit, there was a dispute of if somebody only owned to the 800-foot contour, did they really have the right to cross the land between 800 foot and 795 to get to the waters? The court found yes. It says when that land was sold to that gentleman, Mr. Haley, that Mr. Haley had an implied easement. Furthermore, there was an easement granted on that land by Appalachian to allow access across that property to get to the waters of the lake. So the court held for Mr. Haley in this particular case and said, no, he gets to use that. He has an easement. And the court said, moreover, the deed provided that the covenants and agreements contained therein, the deed meaning the flowage easement in this case, shall be covenants and attaching to and running with said premises. They travel with your title. They're there forever. They're your rights forever. No one can change them unless you agree to have them changed. The court also came back and said, remember I told you that AEP was now reading their flowage easement differently than the way they read it back in 1960. When they signed these agreements, they started to read it with their new requirements embedded in it. Well, the court said, the determination of the easement scope is made by reference to the intention of the parties to the grant, ascertained from the circumstances pertaining to the parties and the land at the time of the grant. In other words, that was a contract that was negotiated in 1960, and the agreements that they made there are the agreements today. It's irrelevant if Appalachian's got a new license. It's irrelevant if Appalachian wants to read the flowage easement differently. It needs to be interpreted as it was agreed to in 1960. The court again said in 2001, this easement did not convey fee simple ownership of that property to APCO, nor did it give APCO the right to grant others the permission to build any docks below the elevation of 800 foot. Thus, the existence of such a flowage easement did not deprive its grantor from exercising the rights of fee simple ownership that were unaffected by that flowage easement. Maybe that's not real clear, but what that says is as long as you don't do something that impinges upon Appalachian's right materially to flood and generate electricity, it's okay to use that land as the fee simple owner in any way that you want to. That was the agreement for 43 years. And if that wasn't clear enough, in 2008, one of these cases in the lower court was before Judge Updike, a judge in Bedford County, in the Circuit Court of Bedford County. He read this during one of his rulings. But the Virginia Supreme Court said in 2001, if Appalachian only has a flowage easement, all they have is an easement, which is a right to flow water up to the 800-foot mark. And they have the right to use that for flowage purposes, but they don't have a right to tell anybody that they can or cannot do something. Pretty direct. I have no authority, this is in his ruling also, I have no authority to extend any property lines. I have no authority to do anything other than make that one determination: has there been interference with the complainant's right to reasonably use the easement for the purposes intended? What this case was a dispute between two adjacent property owners where someone's dock crossed over the imaginary lines drawn into the water and said, oh, this dock is on my property now. It's not the case. The judge says there's nothing about imaginary property lines under the water or in the easement. They don't exist. So therefore, I don't recognize them. I recognize what the flowage easement says. Now, that should be pretty clear right now to us all that the Virginia courts are on our side. And actually, so is the FERC saying, go to Virginia State Court and get a ruling on what the flowage easement means. Well, we already done that 3 times, and it's pretty clear what the flowage easement means. It means what we're telling you it means. It means what we've represented as undisputed facts. It doesn't mean what Appalachian wants you to think it means. Now, in 2001, this was a case at the yacht club, the old yacht club on the Bedford side. And there was a dispute over a property owner, if a property owner had the right to build a dock on someone else's property. And this was a big case. It went all the way up to the Supreme Court. And the Supreme Court was hearing this case, and Appalachian felt compelled to file a friend of the court brief, an amicus brief, okay? And they filed this, and I want to read their words to you right now. Under the flowage easement at issue here, the yacht club plainly retained the right to possess and use the premises in any manner not inconsistent with APCO's rights under the easement. Moreover, to deprive the yacht club of its fee simple interest in this land would be tantamount to an unlawful and unconstitutional taking in violation of the Takings Clause of Virginia and the United States Constitution. The 5th and the 14th Amendments of the United States Constitution provide similar protection. It has long been established that the federal Constitution forbids the taking of property without compensation, no less through its courts than through its legislature. Wow, if that isn't duplicitous, if that isn't ironic, here's Appalachian fighting for their property rights and his landowner's property rights before the Supreme Court. And at the same time today, they're taking your property rights from you without compensation in violation of their words and the 5th and the 14th Amendments to the United States Constitution. Why would they do this? Well, let me tell you why. Because they figured out in this case, if that property owner that owned the yacht club, the land under the water, if that land was reverted to the state, then Appalachian would lose their flowage rights. And that means Appalachian wouldn't be able to operate the project. Self-serving. I would hope that those statements, rather than me telling you what it means, these are extracts actually from the case law and from the briefs that Appalachian filed, would convince you that Appalachian doesn't have sufficient property rights to do what they're doing in this project.